There's one part of Pennsylvania's legal system that's notorious among people in prison for slashing their chances of challenging a wrongful conviction or illegal sentence.
This is the weapon that the lawyers use to stop you in your tracks.
This is how it works. People convicted of crimes in Pennsylvania have a chance to argue that they didn't get a fair trial or that there's important new evidence. It's a process called a post-conviction petition. It's one of the only ways someone in prison can challenge their conviction or sentence. If they can't afford a lawyer, the court will appoint one. But there's a catch. Pennsylvania lets these attorneys reject their clients' claims. They can file what's known as a Finley letter, asking a judge to dismiss the petition without a hearing. If the lawyer gets a judge to throw out a valid legal issue, the client can be barred from raising it ever again. The result is, people who had unfair trials stay locked up for years or decades while they file appeals or hunt for new evidence to clear their names. An Inquirer and ProPublica investigation found that attorneys often file these Finley letters without taking basic steps to investigate the case, like contacting a previous lawyer or speaking with their client. We also reviewed case after case in which attorneys rejected what judges later decided were legitimate legal issues.
Who your favorite uncle?
That's what happened to Philly native Ronald Rogers.
Just recently been released from prison after doing 17 years.
Yeah, I used to live through these photos. I haven't looked at them since I came home, actually.
When I went to prison, my daughter was 1 year old. That's when my son was first born, right after I went to prison. Now that I'm home, I realized that
I want a ball too.
my kids don't have the experience of having a father.
Yeah, that's one of my favorites too. We love you.
Their normal is my dad in jail. My dad in jail, that's all they knew.
You in the back doing cartwheels.
When Rogers was 20, he was involved in a shootout where a stray bullet killed his lifelong friend William Green. Rogers claimed self-defense. So did the other man involved.
I wasn't the aggressor. Trouble just found me, as it always do when you out here in these streets and you living the way, I was living.
In the case of Ronald Rogers, there was one witness who testified that Mr. Rogers was the person who fired the first shot.
This is what my case said. What happened right here.
A witness testified at the other man's trial that Rogers shot first. The other man was acquitted.
But then a week later, he came to my trial and testified and tried to testify on my behalf.
That witness took the stand and changed their testimony, started to say that Mr. Rogers did not fire the first shot. And at that point, the trial judge said to the witness, I'm paraphrasing, but if you change your testimony here in court, you will go to jail. And the trial lawyer sat silently. He did not object.
She recessed for the day. The very next day, he came back, got on the stand, and testified in a way that she forced him to. When she stepped in and did what she did, everything just felt like it was just going left. I lost hope.
That's the house I grew up at right there.
Rogers was convicted of murder and sentenced to 16 to 32 years in prison. There, he started working on his post-conviction filing, where he claimed his defense attorney made a critical error when he didn't object to the judge's warning. He was assigned a new lawyer to investigate his claims.
I got a letter from him stating that he was my counsel, he would be representing me, and he would go over my discovery. Didn't hear nothing from him for a couple months, and the next thing I got was a letter stating that he was planning to file a Finley letter. That Finley letter ultimately led me to staying in jail for another 10 years.
If an attorney investigates the client's claims, reviews the entire case, and still finds no issue, they can instead file that Finley letter, which is also known as a no-merit letter. Retired Philly Judge Barbara McDermott said that Finley letters are necessary to keep the legal system functioning. They allow lawyers to avoid making false or frivolous arguments.
At some point, there has to be finality to cases. We hope that we get it right, but we cannot lose sight of the fact that there are victims. And at a certain point, we have to acknowledge that we're never going to be a perfect system, but within the system we've had, we've done the best we can.
But our investigation identified cases where attorneys rejected their clients' claims just days or weeks after being appointed. We found submitted filings riddled with factual errors and copy and pasted material that named the wrong client. Jennifer Merrigan works at a nonprofit law practice dedicated to post-conviction defense. She saw so many concerning Finley letters that she started studying their use.
We saw them occur repeatedly in cases of wrongful conviction, and we saw them in cases where we knew that our clients had good, viable issues, but did not understand how it was that attorneys were missing them, or why it was that the courts were not catching these serious errors.
That brings us back to Ronald Rogers. His lawyer, Stephen O'Hanlon, declined an on-camera interview, but he told the Inquirer that he conducts a thorough investigation on each case. In Rogers' case, he said the Finley letter was appropriate and emphasized that the judge and prosecutors agreed with him at the time. But the state superior court later sided with Rogers that he deserved a hearing about the judge threatening the witness.
Now that's a big deal because usually the Superior Court doesn't have enough information to know that the Finley letter was wrongfully filed. But in this case, what the trial judge did was so egregious. She's the most powerful person in the courtroom. To use all of that power to coerce a witness to testify a certain way. Even the Superior Court could see that that was improper. Mr. Rogers would still be in prison had the Superior Court relied on the Finley letter and not overturned it.
In 2023, a federal appeals court threw out Rogers' conviction based on the same issue he tried to raise years earlier. His is one of over 250 reversed convictions and sentences in violent felony cases during Philadelphia District Attorney Larry Krasner's tenure. The Inquirer and ProPublica found that in at least 50 of those cases, lawyers had previously filed Finley letters.
This is the weapon that the lawyers use to stop you in your tracks, because at the end of the day, they still getting checks, regardless of if your case is successful or not. Or their caseload might be too heavy, so they don't have time to pay attention to your case. So the easiest way to go is just say, I'm gonna file a Finley letter. And a lot of those Finley letters themselves has no merit.
After the federal court ordered Rogers' conviction overturned, he had a choice. He decided to take a plea deal. O'Hanlon described such outcomes as technicalities and said that Rogers' eventual plea proved he was, in fact, guilty.
I could have sat in jail and took him back to trial and went through the whole nine, but I didn't want to play with it. I felt like my hands was tied. My daughter was turning 18, my son was 17. I feel like I was rushing home to get a chance to spend time with the people I love most, because a lot of them dead. When I was in prison, a whole generation of family members died. You become the person that people look to for advice. I just couldn't wait to come home and embrace these things that's required of me. And I don't plan on abandoning my post ever again.
Sheesh.